Hello everybody. I will do my best to lecture in this format. It's very awkward and I don't really know how to use the technology, so if you hear me breathing heavily into the microphone, I'm sorry, but I'm doing my best. Alright, we're talking about motions today. Motions are, generally speaking, when the parties ask the court for something. A motion is asking the court to do something, order something, grant a party time to do something. Motions are often written and filed through the e-filing system, CaseNet in Missouri. They are also often made orally. For example, where the lawyers are at a hearing with the judge for a different reason, and they simply ask the judge to grant them something. For example, at a case management conference, it's typical for lawyers to ask the judge for leave to amend the complaint or permission to amend the complaint, or ask the judge for an extension on certain deadlines when the lawyers are there at the court anyway. Those are oral motions. Sometimes when motions involve complex or important issues, the parties submit written legal briefs, which are memoranda. And also often there are hearings on motions where the court will have the lawyers in to give oral arguments, where lawyers will orally state their arguments. It's what it sounds like, and the judge will either give a decision or think about it and make a decision later on. Motions look like pleadings. They have caption, paragraphs, but they aren't. Recall, pleadings are for the purpose of defining the dispute, where motions are, like we said, asking the court to do something or make a decision. A little bit of definitions first. The movant is the person that's making a motion. When the motion is filed, it is noticed, meaning that all parties are given notice or are made aware that a motion has been filed. And when a hearing date is set, all parties need to be made aware of when the motion will be heard by the judge. So everybody has a chance to be there and to give their argument about whether it should happen, shouldn't happen, or let the judge know if they have no objection to the motion. In Missouri, timing-wise, the motion needs to be served on the defendant if it's an electronic way like email or through the e-filing system, at least 5 days before the hearing. If it's by mail, it adds a few days, but with the e-filing now, you could just assume 5 days for timing. The motion is set with the coordination of the court's clerk, of the staff with the court, checking availability with the judge, checking availability with the other side, and selecting the hearing date that way. And it's done differently depending on the court, depending on the judge. It's done differently in federal court. It's done differently in different states. The easiest way to find out how to set up the motion is just to ask the clerk. The non-movant, we talked about the memo in support, by the way. When they're written motions and it's a complex issue or complicated issue, a memorandum or a legal brief should be filed with the motion. Motions for summary judgment, for example, need to have a written brief with them. Other ones don't necessarily need it. When there's a written brief with the motion, the non-movant, who is the other party, should file a response with their own legal brief. Then after the response, the movant, the person bringing the motion, the party bringing the motion, has a chance to file a reply, another brief, and if there are new things in the reply, the non-movant has a chance to actually file a sur reply. Though you're not going to see a lot of sur replies. three general types of motions that we'll talk about. Broad categories are pre-trial motions, motions that are made before trial, motions that are made during trial that relate to the evidence, and then there are post-trial motions that are brought after the trial is over, after the jury has rendered a verdict. A non-exhaustive list is here of common pretrial motions. There are obviously many more than this, but this is a list of fairly common ones. Motion to dismiss, motion for voluntary dismissal, which is a little bit different, also called a non-suit. Motion for a more definite statement, motion to strike, motion to amend or leave to amend, a motion for judgment on the pleadings, motion for change of venue, and a motion to quash service or quash summons. And there are discovery-related motions that are pretrial motions, like motion to compel or a motion for a protective order. Then MSJ, or a motion for summary judgment, and sanctions. Starting with the motion to dismiss. This type of motion asks the court to dismiss some or all of the complaint. The federal rule is 12B, and the Missouri rule is 55.27. Some bases of a motion to dismiss could be lack of jurisdiction, that the court doesn't have jurisdiction over the subject matter or over the parties. The lack of legal capacity. For example, there's a minor bringing a suit in an incorrect way, or somebody with what's called an intellectual disability in the term of art that doesn't have the capacity to sue, that's bringing a lawsuit. And then, and there are others, but the biggest one, the one that you'll see most common, is the failure to state a claim upon which relief can be granted. Motions to dismiss in federal court have to come before the answer. In Missouri, it can be filed at the same time as an answer. But in federal court, just know that if there's an answer filed, that waives the right to file a motion to dismiss. The failure to state a claim. Motion to dismiss for failure to state a claim upon which relief can be granted. This is the most common type of motion to dismiss that you will see. The standard here is the court assumes that everything in the complaint or petition is true. Looking at everything, assuming that it's all true, the court asks, do the allegations meet the elements of the claim? Does the complaint or petition actually plead all the elements so that if the plaintiff proves everything in the complaint, does that actually state a valid cause of action? Are all the elements there? In other words, is the complaint or petition valid on its face? The court does not ask whether the plaintiff is likely to prove the allegations or whether the plaintiff has a good case. The court simply asks if the plaintiff proves the things that the plaintiff is alleging, does that actually state a case? If this type of motion is granted, the plaintiff can ask for a dismissal without prejudice, and then the plaintiff has a chance to try again, basically, to amend the complaint to fix the problems that led to the dismissal in the first place. So it's not the end of the world for a plaintiff to lose a motion on these grounds if it's possible to cure the complaint with an amendment. Similar name, but a different idea. Motion for a voluntary dismissal, or in other words, a non-suit. This is where the plaintiff is dismissing some or all of his or her own case. This is done for a couple of reasons. The plaintiff can dismiss different parties without dismissing the entire lawsuit. For example, I have a case where I sued a hotel recently. Didn't know who the owners were, really. It could have been a few people. There had been a recent transaction. I didn't know who exactly the management company was because there are different management companies that have the liquor license. There's a different management company that evidently operates the hotel. There's the old management company that used to operate the hotel until a couple of months before the accident. So I named all of them and then figured out who was correct and who was incorrect and voluntarily dismissed the incorrect parties, or in other words, non-suited the incorrect parties, and that's common. Another reason that a plaintiff can voluntarily or does voluntarily non-suit their own case is if there's a problem with the case and they need basically a free punt. And the reason that that's possible is what's called a saving statute. And the saving statute means that if the plaintiff voluntarily dismisses their case, they have 1 year to refile. They get to do that one time. A plaintiff gets one free punt. And I'll say that again. If the lawsuit is filed on time, the plaintiff has one chance to dismiss their case or a defendant and then refile the case or against that dismissed defendant within 1 year. They can do that one time. And many states have this. It's very similar in Missouri and in Illinois. In Missouri, what's important to note is that the 1 year runs from the date of the filing of the motion, where in Illinois, the 1 year runs from the date the order is granted. I'm not going to test on that, but just something to keep in mind. The federal courts do not, when they're applying federal law, have a saving statute. So cases can only be refiled if they're voluntarily dismissed, if it's still within the statute of limitations period. In the second scenario I talked about, where there's a problem with the case and we need to punt, we need to basically start over, or at least fix some things and bring it again. A couple different scenarios where I've done that. One, I took a case over from somebody else who had, in my opinion, screwed it up, not alleged different things that I thought would have been important to allege. They didn't file a strict liability count. I thought, and it was a dog bite case, I thought they should have. So I non-suited the case, refiled it right away, fixed some things, and it only delayed everything by a month or two. And it actually ended up working out. Another instance was a case that I had where the plaintiff, we had trial set, and she had decided to schedule an international vacation for a couple of weeks during the time that we were going to be on trial. Of course, we needed to have her there. She wasn't willing to cancel the vacation, so we ended up punting, filing the non-suit, and then refiling, and that ended up working out as well. So that is a useful tool to have. Motion for a more definite statement or motion to strike. This one is filed typically by the defendant in response to the petition or the complaint, where the defendant is, and this is the motion for a more definite statement, the defendant is asking the court to make the plaintiff replead the complaint with more particularity. They're saying the complaint's too vague. I can't answer it. I can't admit or deny anything. So the plaintiff needs to refile it so that I can sufficiently respond to the complaint, that I can know what I'm admitting to or denying. Motion to strike is where the court can order, basically thrown out from any pleading, anything that's redundant, that's not relevant, or that's scandalous. It's a fairly high standard. Basically, the allegation has to have no relation to the case and be prejudicial to a party. So basically, if there's something that's only put in there to make a party look bad with no relevance to the case, it'll get thrown out under a motion to strike. Motion for leave to amend. This is in Missouri 55.33. The federal rule is 15. Sometimes the complaint simply needs to be amended. And things need to be changed. Either parties should be added or different counts should be added against the same parties, or the existing counts, maybe the lawyer wants to tinker with them and wants to basically just improve them a little bit. This sometimes can be done without the leave of court, meaning without asking the court in a motion. Often does have to be done with asking the court in a motion. It can be done without leave of court when in Missouri before any defendant responds to the complaint. So when a petition is filed, before any defendant responds, the plaintiff can, without asking the court, file an amended complaint. Also, in Missouri, within 30 days of the service of a defendant, the plaintiff can amend without asking the court. So within 30 days of service, the plaintiff can amend. And there's a similar rule for that in federal court, but it's just a bit shorter amount of time. Other than those two situations, before any defendant responds or within 30 days of service of a defendant, the plaintiff needs to ask the court for permission to amend the complaint. And that's what leave means. It's basically permission from the court to do something. And here the lawyer is asking for permission to amend the complaint. The good news is it is easy to get leave to amend the complaint. The court is instructed to grant leave to amend freely when justice requires. So basically, they do it very liberally. The court will grant parties leave to amend the complaint whenever it appears that that it makes sense to do so, that justice requires it. One issue that comes up with amending complaints pretty often is when a party is trying to add, obviously new stuff to the complaint, a new cause of action against the same defendant, or add a new defendant to the complaint, and the statute of limitations has run. So the question is, can we add new stuff to the complaint after the statute of limitations? There is a doctrine called the relating back or the relation back doctrine, where we will essentially pretend that the new stuff, the new complaint with either the new cause of action against the same defendant or the new defendant was filed on time before the statute of limitations had run. For example, say I have a case where a plaintiff is walking on a sidewalk and is bit by somebody's runaway dog, and they had not provoked the dog. And so we had sued them for negligence because the homeowner had a hole in their fence that let the dog run away that they knew about. And then the statute of limitations runs. And we realize, hey, we should have added or we should have included a strict liability dog bite law count. And we want to amend the complaint against the same defendant to add this new strict liability count. We can do that under the relate back doctrine because you can add new counts against the same party if it arises from the same incident, from the same occurrence. So you can add counts against the same parties, the same defendants, if the new counts arise from the same incident. That is not the case with new parties. If you're trying to add new defendants, it is much harder. For example, in this hypothetical, we learned that there was a contractor that had worked on the fence, that knew the dog was dangerous and had removed the fence and let the dog out. So we want to sue them for negligence, the contractor. They would be a new party. You cannot name the new party in this situation after the statute of limitations unless it comes from the same incident and the new party was on notice that they should have been named in the original complaint, if not for a mistake in the complaint. So essentially, without a mistake in the complaint that the new party knew about, you're not going to be able to add new parties after the statute of limitations. So to review, I know it's a little bit of complicated of a doctrine. New cause against the same parties does relate back, meaning it is considered timely after the statute of limitations if it arises from the same incident that the other counts arise from. But new parties, we can't get that complaint to relate back unless the new party was on notice of a mistake in the complaint, and they knew that that's why they weren't named in the first place. It's pretty limited. So, as an example, say that we want to sue the homeowner for a car accident that had happened 10 years ago. We're already suing them for the dog bite that had happened, 5 years ago. Can we sue them for a car accident 10 years ago? It's the same party. No, because that's a new cause of action that did not arise from the same occurrence. It did not arise from the same incident. So that would not relate back. Motion for judgment on the pleadings. It's rare. The Missouri rule is 55.27b. Federal rule is 12c. It's sort of a hybrid type of motion where it's a lot like a motion to dismiss, but after the pleadings are done. So there's a petition filed or complaint, and the defendant answers, and the parties are about to move on to discovery, or even they have moved on to discovery. The defendant can file a motion for judgment on the pleadings, which is basically a motion to dismiss after the pleadings are done, saying that the complaint had a problem, and so that the judge should rule in their favor. The problem with this kind of motion is it's just like a motion to dismiss, where the judge will freely grant leave to amend the complaint to fix the problem. Where I've heard of this being recommended, I remember my civil procedure professor was all about it for some reason, is I suppose it could put pressure on a plaintiff's lawyer, for example, an inexperienced plaintiff's lawyer that doesn't know what to do with it or asks the court for leave. It just sort of puts pressure on them. They don't, because now all of a sudden they're facing this funky motion after the pleadings are done to dismiss the complaint. But you're not going to see a lot of this, I would expect. Brings us to motion for the change of venue. Nationwide, there are two types of change of venue motions that you will see. And that's in federal court, that's in most states. Missouri is a little bit different. Has a couple of extra reasons that parties can try to get venue changed. Recall that venue in Missouri court refers to the specific county where the case is brought, where the case is filed. In federal court, it refers to the specific federal district where the case is filed. So in Missouri and everywhere else, the two most typical reasons to move the court or ask the court for a change of venue is, number one, if the venue, the county, is not proper, meaning that the case was not filed in an appropriate county or federal district. And then if that's true, the court will dismiss the case in the county and transfer the case to a correct county. In Missouri, the defendant needs to file a motion to change venue for improper venue within 60 days of being served. So you need to be aware of that time limit in practice. And then the procedure is the defendant will tell the court where venue would be proper, and the court will then transfer the case there after hearing argument on the issue if the plaintiff contests the change of venue. Another change of venue basis is if the venue is inconvenient. So in a forum non-conveniens motion is what it's called, or a motion to change venue because it's inconvenient, the venue is appropriate. However, the parties are saying that, or one of the parties, usually the defendant, would say it's so inconvenient that the judge should send the case to a new county, even though it's an appropriate venue where it is, where the case is. Usually it's because all the parties are located in a different county. So all the depositions are going to need to take place in a different county. And that would be a reason, and that's usually the most cited reason why defendants bring motions to change venue, because of inconvenient venue or forum nonconvenience. Another reason that defendants will bring up that courts factor into their decision is if a new county or a different county has a less burdened court, so it would be a more speedy resolution of the case. Courts are supposed to consider that basis, but in reality it usually just ends up sort of bothering the court when parties argue it. It is a narrow type of motion. It's not going to be granted a whole lot if there's a proper venue and a party's trying to move it because it's inconvenient. In Missouri, there are other ways to try to get venue changed. Where a county has less than 75,000 people in terms of population, a litigant can get that venue transferred as of right. So if I were to file, and I got a list on the next slide, in, for example, Pulaski County, the defendant can, as of right, ask the court to transfer, and the court will transfer the case because there's less than 75,000 people that live in that county. And here's the list. Cole County just makes it. Cape just makes it. Here and down, we are less than 75,000, and the defendant can transfer the case if they want to. Motion to quash service is another one that you may see. Quash is a fun name, a fun legal term of art that basically just means the court declaring something invalid. So a motion to quash service would be a party asking the court to declare that service has been invalid, that something is wrong with the service itself or with the summons. So say the summons has a wrong name on it, that you have, the plaintiff has basically just put the wrong name on the summons, and then the defendant is served with summons. They can move the court to quash service, meaning to declare that that summons had been invalid, so there had been no effective service. Or, for example, if the process server, instead of handing the process to somebody that lives in the house of appropriate age, they had left it with the baby or just left the complaint in the mailbox, the defendant can move to quash service and ask the court to declare service invalid, saying that it was not served correctly. Many places, including federal court, there is also an option to ask the court to declare service invalid and actually dismiss the case if service of the complaint was not done diligently. In federal rule, that's 4M, where the complaint has to be served within 120 days unless the plaintiff has a good reason why they weren't able to get it done within that amount of time. Illinois has a rule, 103B, where the defendant can ask the court to dismiss the case because the plaintiff basically took too long to serve them and wasn't making reasonably diligent efforts to get service completed. And that's a fairly frequent motion that's brought when service is done 6 months or more down the road, and cases do get dismissed. I had a case where for some reason I was defendant and I got a case dismissed under 103B. Missouri does not have a requirement for diligent service, meaning a case cannot be dismissed in Missouri because a plaintiff was lazy, was not diligent in serving. It's always obviously good practice to be diligent, but there's not that same kind of procedural device in Missouri to get cases dismissed for lack of diligent service. All right, let's do a quick review. Movers and shakers, the pleadings motions. I'm going to describe what we want to do, and we'll go through what that type of motion is. So number one, I want to ask the court to dismiss the case because it's missing an element, it being the complaint. So I'm the defendant. I see the petition or the complaint, read through it, and it's missing an element. And I want to ask the court to toss this complaint out. Maybe the plaintiff will be able to replead with the missing element. Maybe they won't. What type of motion is that? That is a motion to dismiss for the failure to state a claim. Next one, I want to ask the court to get rid of, one paragraph in the complaint that's irrelevant and is harassing. Say that there's a paragraph that just says in its entirety, the defendant is a jerk. I want to ask the court, hey, this has nothing to do with the case. This is just mean and is in there to make them look bad and harass. Let's get this tossed out of the complaint. What kind of motion is that? That is a motion to strike. Next one, I want to ask the court to dismiss some or all of my own petition, my own complaint. I figure out that some of the defendants that I had named, I'm the plaintiff, I named a bunch of different defendants, and some of them are incorrect. They have no business in the complaint. What type of motion is that? That's a motion for voluntary dismissal or non-suit. And remember, if I let the party out, I can refile against them one time within 1 year. So there's not a huge amount of risk to letting an incorrect party out. Obviously, you should be convinced that they're incorrect. But once you let them out, you could refile against them within a year. You get that one free punt. Next one, I want to ask the court to make, and I'm the defendant, I want to ask the court to make the plaintiff clarify things in the petition so I can respond. And I'm sorry I keep mixing, I keep using both terms, petition, complaint, but hey, that's just how the cookie crumbles, my friends. I get the complaint, and it's vague. It makes no sense. I don't know if I can even admit or deny to these things because I just can't make heads or tails of what the plaintiff is trying to claim. What type of motion do I need? That is a motion for a more definite statement. Next, I want to ask the court to transfer the case to a different county. Say it's where the case has been filed is an incorrect county. That's a motion for change of venue. Here, because it's been filed in the improper county. Now say that I want to ask the court to transfer the case to a different county because all the witnesses are in that county anyway. We'll get the case done faster in that county. And this is a correct county, but the case would be done much more efficiently, much more economically in a different county. What type of motion is that? That is a motion to transfer counties, or motion for change of venue, I should say, for forum non-convenience. Motion for change of venue, in this scenario, for forum non-convenience. Say I am the plaintiff, and I want to tinker with some of my allegations. I just want to change the wording of some things in the petition. I want to amend. What type of motion is that? That's a motion for leave to amend. Leave to amend the petition in this instance. And again, that's freely granted by the judge if justice requires it, meaning the judge will almost always grant a motion to amend the complaint. Say I want to ask the court to declare the summons that the plaintiff had issued and served on my client, the defendant, I want the court to declare that that summons was invalid because something's wrong, something screwed up about the face of the summons itself. They had put the wrong name on it, for example. What type of motion is that? That is a motion to quash service. Now, say that we have a correct summons. The complaint's been filed. The defendant has filed an answer to the complaint, and we're starting discovery. But I, the defendant, want the court to enter judgment for the defendant because something's wrong with the complaint. Something's wrong with the petition, and even though I answered it, let's try to get it dismissed now. What type of motion is that? That's a motion for judgment on the pleadings. All right, moving on. Discovery motions. Two main type of discovery motions. First one is a motion to compel, and the second one's a motion for a protective order. Motion to compel, and recall, discovery is where the parties are asking each other to exchange information. And when parties are exchanging information, sometimes there are things where, I know that what the other side is requesting, I have, but I don't want to turn it over, or I think I don't have to turn it over. Say I have tons and tons of documents, and the other side has asked me a very broad request. Give me all, say all medical records in your life, which, by the way, probably is okay. Well, probably should be more narrowly tailored, possibly, depending on how many records. But say I have a ton of records, and I might bring an objection to that. I might state an objection to that request, and I'm saying it's too burdensome. It's overly broad. You're not tailoring the request, and so I don't produce anything. Well, the party making the request can then bring a motion to compel, asking the court to make me turn over documents that I have, or make me turn over information that I have withheld from discovery. So the party seeking the information files a motion to compel and asks the court to order the other party to turn over the withheld information. Often the court will look at the requested information or the requested documents on its own, and that's called an in-camera inspection, and will then say whether the information is appropriate for discovery and make the party withholding send it over. Or the court can just look at the request itself and say, hey, this isn't overbroad. That's fine. That's tailored enough. And make the party withholding send over that information or send over those documents. Another type of discovery motion is a motion for protective order, which is usually less contested. Not all the time, but sometimes. And that's a court, or that's a party that is withholding information that wants to limit, prevent sending over the information, or to put conditions on sending over the information. Often where you'll see this is where a corporation thinks that their documents are trade secrets. Maybe they are, but usually they're not. Maybe they are. And the corporation will move for protective order so they can stamp the documents confidential. When it turns things over for attorney eyes only, it'll stamp it so it's confidential, and the attorney then can't show other people the information that it received. Also, motion for protective order could be done sort of offensively when an overbroad request comes in, or an objectionable request, and the party will move for a protective order to limit what it has to turn over, because it knows that it has some things that are discoverable, some things it will have to turn over, but doesn't want to turn everything over. So it'll ask the court to limit or bar, or prevent it from turning everything over. There will often be a requirement called a meet and confer requirement, or a requirement to make a good faith informal effort for the party to try to work out the issue without having to actually ask the court. And that goes for motions to compel and protective orders. That a lot of courts will have a requirement that the parties meet and confer, meaning they meet, talk, although a phone call will do the trick, and often a letter does the trick as well. That a party makes a good faith informal effort to work out an issue before bringing a motion to compel or a motion for a protective order. Because the idea is, why waste the court's time if it's an issue that the parties can agree about? Parties can often agree about these types of issues. Federal court has a meet and confer requirement. Other states have meet and confer requirements. By the way, the federal court's meet and confer rules right there in the rule for motion to compel and protective order 26C1. Illinois has a meet and confer requirement. Missouri does not have it in the Supreme Court rules, has it oftentimes in the local rules of court. So be sure to take a look at the rules of court, and they will often require parties to have an informal either phone call, maybe letters, to try and work out the issue before wasting the court's time and bringing a motion to compel or a protective order. Not necessarily wasting the time, but taking up the court's time. And the reason for that is judicial economy. The court wants to save its time if possible. Some more, very common discovery-related motion is motion for extension of time, which can be done for, different deadlines, but often for discovery deadlines. The easy way to do it is to get the other side to agree that everyone or you can get an extension on a discovery deadline. Say interrogatories and requests for production, that responses are due. You just need another 30 days. Ask the side, try to play nice, say, can I get another 30 days to answer? And they'll, usually, if they're okay, and you've been good throughout, they'll say yeah a lot of the time. Even if the other side agrees and you stipulate, we can extend the discovery deadline. It's always good practice to file a motion with the court before the deadline. Missouri Rule 44 tells you file it. You can bring it as a consent motion, meaning that everybody agreed, or an agreed motion. But file the motion and do it before the deadline has run. Then there's the hard way, and that's where parties aren't getting along, discovery deadlines have been missed, and one of the parties files a motion for sanctions against the other party that's missed discovery deadlines. The court can, and often does, grant that the other party, the non-movement, a chance, a week or two to finish discovery before the sanctions set in. But not necessarily. That's the hard way to do it. It's always better to file a motion before the deadline, whether or not the parties agree, rather than, going to the court hat in hand and saying, please give me an extra week to finish things. Sanctions are penalties. Some penalties that can occur for missed discovery deadlines. The judge could dismiss the plaintiff's case if the plaintiff is missing the discovery deadline. If it's the defendant missing the deadline, the judge could enter default judgment against the defendant. The judge could prohibit the party from introducing evidence and even award fees and expenses, meaning that the judge will make one party pay the other party's costs and legal fees. That's rough, and you want to avoid that if at all possible. Be on top of deadlines, and if there's a deadline coming up, you might not make it in time, be sure to file the motion before the deadline. Motion for summary judgment. This is similar to the idea of a motion to dismiss. However, this one is done after the close of discovery. So the timing of this one is after discovery, meaning that the parties know the information that will be presented at trial. And one of the parties, usually the defendant, will then bring a motion and say, after discovery, now that we know everything, the plaintiff cannot win. No reasonable jury can find for plaintiff. That type of motion can be supported by affidavits, which are statements that are signed under oath with a notary, that will take the place of testimony at trial if there are other things outside of discovery that the party wants to include. By the way, a motion to dismiss that includes an affidavit or things that are outside the complaint is converted into a motion for summary judgment automatically, and the parties get to then go through discovery. The idea of a summary judgment is that the case is so bad that the judge should put it out of its misery. That, of course, is not the legal standard in legalese. The standard that the judge is considering is that there is no genuine issue of material fact, meaning that there's no real issue for the jury on each disputed fact because the fact is so strongly in the defendant's favor, in one party's favor. For example, I had a case a while ago where I lost a motion for summary judgment. I had the plaintiff. He had slipped playing basketball at a YMCA. And after he slipped, he says he felt a shoe and it was wet. He didn't really know where the water came from, but it had been raining. And through discovery, I found out that there are these big kind of bowls that caught water in the roof. And I was trying to show that the water came from the roof, and it had been raining that week. It was a stretch, though. It was tough because I didn't know exactly where the plaintiff fell on the floor and if it was in the area of some of these water bowls. And actually, it seemed like it wasn't in the area. The judge threw the case out and granted summary judgment because he found that there was no genuine issue of material fact, meaning that no reasonable jury could find that my client had slipped in water that came from the roof, that came from negligence. So that disputed material fact of where the water came from, there was no genuine issue. There was no real dispute because my evidence was so bad that a reasonable jury could never find for me. These motions are very particular in terms of the form. You got to read the rule, read the local rules. 74.04 is a Missouri rule, and federal rules is 56. So in Missouri, there's a motion, and then with the motion, there has to be included a statement of all the facts that the movement is arguing that is in their favor, meaning that there's no genuine issue of material fact. So there's a statement listing every fact that the movement believes no reasonable jury could decide in the other party's favor. Also, there has to be a written memo supporting the motion, which is a written legal brief. And then all the exhibits, all the testimony, all the affidavits that support the motion have to be attached. It's very particular in the form. Read the rules and the local rules of court. The non-movement gets 30 days, and usually the non-movement's the plaintiff, gets 30 days to respond to the motion. Has to then admit or deny from the statements that are made in that list that the defendant had set over. The defendant has a chance to reply to the response brief. And by the way, I don't know if I said the plaintiff's response is called a response. The defendant replies to the response within 15 days of the response. And if the reply brings up more material facts, the plaintiff needs to file a SUR reply, S-U-R reply, within 15 days. Motions to dismiss versus motions for summary judgment. They're distinguishable on a few different bases. Number one, when they are brought. Motions to dismiss are brought after a defendant receives the petition or the complaint. A motion for summary judgment is brought after the close of discovery. The purpose of a motion to dismiss is to get judges to quickly reject crappy cases, to get the judge to quickly reject a frivolous case where even if the plaintiff proves everything, still can't win. So why even waste our time going through the hassle and the expense of discovery? A motion for summary judgment is a little bit different. It's a gatekeeping mechanism, but after the expense of discovery, plaintiff can never prove the case at trial. The complaint looked good, high hopes, but can never actually prove this case at trial. So judge, let's toss this instead of giving it to a jury. And the motion for summary judgment can be brought by anyone. It's usually brought by the defendant. And the legal standard also is different. Motion to dismiss, the legal standard is taking the complaint on its face. Does it adequately state a cause of action? Are all the elements there adequately stated? A motion for summary judgment, we're asking, is there a genuine issue, or the court's asking, is there a genuine issue of material fact? Can a reasonable fact finder actually find for, say, the plaintiff in this case on every issue? If the answer is no, the case gets thrown out. Trial motion. There are two general types of trial motions. The most common one are motions in limine. During motions in limine, the courts ask the judge before the trial is actually started, though I suppose they can be brought during trial as well. But the parties are asking the judge to exclude certain evidence. So, I might bring a motion to get a judge to exclude irrelevant evidence about what a plaintiff did before an accident. For example, I have a case where a guy was hit on a bicycle. Before the accident, like a minute before, he cut around the bus. He was hit by a bus. He cut around the bus. It's not why the accident happened, but it looks terrible. So I might ask the judge to exclude that evidence in a motion in limine. Or I have an exhibit. It's a picture of hardware that goes on a collarbone, that the plaintiff had collarbone surgery with hardware. And the defendant feels that the picture I have does not accurately represent what the hardware looks like. So opposing counsel, she's trying to ask the judge in a motion in limine to keep out that evidence, to keep out that exhibit that I have, so I can't show that picture. A motion for a directed verdict, which is Missouri Rule 72.01, it's done after the opponent's case, before the jury renders a verdict, asking the judge to rule in their favor. It's basically a motion for summary judgment without the same technical written requirement. That's done during the trial, after the opponent's case has been presented, before the jury renders a verdict. So say I put my case on the guy with the bus, and the defendant feels I have not proven my case after my close of proofs at trial. The defendant can ask the judge to determine that no reasonable fact finder could find that I have proven the case, and throw the case out before a jury renders a verdict. That's a motion for a directed verdict. Post-trial motion. Motion for a judgment notwithstanding the verdict, which is also, for some reason, called a JNOV. That's based on the Latin for that phrase, which I don't know and I don't expect you to know. That's 7201, which is the same as the directed verdict, but it's just the timing of it. The motion for judgment notwithstanding the verdict or JNOV, is made after both sides are done, and it's made after the jury's given the verdict. Typically, that's when the JNOV is brought. It's the same standard, though. In a JNOV, or judgment notwithstanding the verdict, the party is asking the judge to throw out the jury verdict because no reasonable jury could have found for the other side. So, say in my bus case, bus versus bike, directed verdict is denied. The jury finds in favor of me, but the defense still thinks that my case is terrible, that I didn't prove the case. The defense can ask the judge to throw out the verdict and enter a judgment notwithstanding the verdict in the defense's favor. So ignore the verdict, still enter judgment in the defense's favor, because no reasonable fact finder could have found that way. Motion for a new trial is something that will often be pled or be pleaded at the same time as a JNOV. We're just asking the court to retry the case. That's going to be done by the salty party, the party that's lost. It's going to ask the judge to redo the whole thing. Let's run it back, judge. Motion to vacate or modify judgments is Rule 75.01. Within 30 days of any final order, doesn't have to be a jury verdict. It can just be a final order, say, dismissing the case or dismissing part of the case. Party can bring a motion to modify that judgment within 30 days. Just a quick review of the new things that we went through. All right, let's say that that discovery is over. I want to ask the judge to throw out the plaintiff. I'm the defendant. I want to ask the judge to throw out the plaintiff's case because after discovery, that case still stinks. They can't possibly prove their case. What type of motion is that? That's a motion for summary judgment. Say at trial, I want to ask the judge to exclude certain evidence that I find is irrelevant, for example, or I find violates the rule against hearsay. That is a motion in limine. For example, say the other side has put on their case in trial, and I want to ask the judge before the jury renders a verdict, find in my favor. What type of motion is that? That's a motion for a directed verdict. Then say the verdict is given, goes against me, but I still think, by the way, you don't have to bring the directed verdict first. Say I'm at trial, verdict goes against me, but I think that the other side did not prove their case. What type of motion is that? That's a JNOV, or a motion for a judgment notwithstanding the verdict. That's all for this week. I know this has been a lot of information in a long video. I appreciate you watching and listening if you made it this far. Thank you.